we wait for complete reports. That is my office's policy.
You can't prove and charge any of these, so you don't want to file anything?
I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then we cannot have bail. So you are discharged from all bail forthwith. Now, cash will be returned.
A man and his wife walked 2 hours to reach a courtroom in rural Wisconsin, not knowing they were walking into a legal scandal that had been hiding in plain sight for over a month. His name was Brandon Campo. He had no lawyer, no transportation, and as it turned out, no actual charges filed against him. Yet for 33 days, he had been living under a $1,000 cash bond, terrified of violating conditions tied to a case that, on paper, did not exist. How does a man get jailed, bonded, and bound by court conditions for a crime no prosecutor has formally charged him with? The answer exposes a quiet but explosive failure inside the American justice system. And it took one judge to drag it into the light. Campo was arrested on May 22nd. 4 days later, on May 26th, a court set his cash bond at $1,000 based on a police probable cause statement, the document officers submit describing the facts that justify an arrest.
We will go on the record in the matter 26 GF 133 group file of Brandon Campo. Appearances are we do have appearing in person the District Attorney Kevin Schmidt. Mr. Campo appears in person without counsel. We are in victims' rights compliance because the victim is sitting right back there, Ms. Bauer. That is the victim. Look at her face. That is who she is. And so we have Mr. Campo here. This matter, he was brought before the court for the court to put him on a cash bond, a significant cash bond on May 26, 2026. There was enough there for the court to make a probable cause finding because the court does have at least a small police report in this matter.
Probable cause is a relatively low legal bar. It means there's enough evidence to believe a crime probably occurred. It is not the same as a formal criminal charge, which is what actually triggers prosecution, court dates, and a defendant's right to know exactly what they're accused of. Campo had cleared the lower bar. He was still waiting weeks later for the higher one.
I was trying to get the court date changed because I don't have an attorney.
Because you don't have an attorney, but I understand that, but you don't even have charges filed against you. You understand that part?
So I didn't have to appear?
I would say probably no, because there's nothing filed, but you do have cash, $1,000 cash that was posted based upon a very lengthy probable cause statement with facts enough that you could have been charged or probably should have been charged by now, since it is June 24th. Almost a month past the date. You are dressed very nice for court. Thank you for wearing a shirt and a tie. You look fantastic.
By the time he appeared in court on June 24th, almost a full month had passed, no complaint, no formal charges. Just a man in a shirt and tie walking miles because he couldn't afford a car, just trying to get a court date changed for a case nobody could tell him the status of.
Mr. Campo? This is a 1 o'clock, but it is a GF. And this man and his wife just walked 2 hours to be here this morning. And I don't believe that we have anything filed, do we?
This is where the hero of this story enters the record. The presiding judge looked at the file, looked at the calendar, and did the math out loud.
Why don't we have anything charged? Almost 1 month to the day or two later.
Because one of the charges lacks probable cause in the police reports.
Then don't charge that charge, but he should be charged by now.
No.
33 days, 1 arrest, 0 charges, and a man still bound by bail conditions for an accusation that legally did not yet exist. The judge turned to District Attorney Kevin Schmidt and asked the obvious question, why hasn't this been charged?
By now.
No, because I've asked for police follow-up to find the probable cause for that count.
I thought you started something in Polk County where the day that they're arrested, they get a probable cause, they get their initial appearance, they have a complaint filed. This should happen here too, because it's almost 1 month since this man was arrested, put on bail.
Schmidt's answer became the moment that would define this entire case. We wait for complete reports, he said.
Judge, we wait for complete reports before filing complaints because our policy is that cases are provable and triable the day we charge them. It's not right now. That is my office's policy.
That is my office's policy. Then he added something that would prove fatal to his own argument. I don't charge based on probable cause. I charge based upon beyond a reasonable doubt. Here's why that sentence matters, and here's where the law and the drama collide. Beyond a reasonable doubt is the standard required to convict someone at trial. It is the highest bar in the American legal system. Probable cause is the standard required to arrest someone and set bail. They are not interchangeable, and a prosecutor is never required to meet the trial standard just to file a charge. By saying he charges based on the trial standard, Schmidt had just admitted, on the record, that his office was holding people on bail indefinitely while refusing to file charges until they were essentially trial ready.
And again, I don't charge based on probable cause. I charge based upon beyond a reasonable doubt.
Then we cannot have bail. Then we cannot have bail or bond conditions. So people need to be let out immediately, forthwith.
We can have bail conditions set based upon probable cause statements, and the complaints can be filed forthwith. We have the capacity to do that so long as law enforcement...
The judge caught it instantly. Then we cannot have bail, the judge said. If the office wasn't ready to charge, it had no legal basis to keep a man bound by conditions in the meantime.
Correct. If the court conducted a bond hearing within 72 hours of arrest, I could have told the court this, but our county doesn't do that.
Our county should do that. Our county should do that, because I guess I'll pull up the statute right now. Because people's rights are restricted.
Have you ever worked for a boss who set a deadline for you but exempted himself from ever meeting his own deadlines? That is, in essence, what was happening to Brandon Campo. The rules that restricted his freedom were not being applied to the people responsible for charging him. The judge wasn't finished. Wisconsin law requires that when someone is arrested without a warrant and brought before a judge, a criminal complaint must be filed forthwith, a legal term meaning immediately, without unnecessary delay. Courts have generally interpreted that delay as no more than 48 hours.
The state must file a complaint without unnecessary delay following arrest, which generally can be interpreted as 48 hours. 48 hours. And that's not just for the court to determine bail, but it should be filed. It should be filed with unnecessary delay. And
Brandon Campo had waited over 700.
When a person is arrested without a warrant and brought before a court, before a judge, a complaint shall be filed forthwith. Forthwith.
This person was never brought before a judge. Bond was set in his absence.
The DA pushed back, insisting his office's internal policy required complete trial-ready reports before filing anything. The judge pushed harder, noting that other counties managed to file complaints the same day as arrest, using the same probable cause statements already sitting in the file.
The next day we'll have the initial appearance. That was forthwith for the court. So is that what we're going to do, Mr. Schmidt?
I'd have to confer with law enforcement because they have not been consulted with this yet and not been given an opportunity to prepare.
There's enough. Do you understand what the PC comments or complaints that are filed, the probable cause complaints? They have a lot of information. They are puked with a whole lot of information. The officers do such a fantastic job for the most part in those probable cause statements. Enough where a complaint can be filed. Enough. I can even read this complaint that was filed by the Siren Police Department. There is enough there, right there, enough there that a complaint can be filed. That is
the judge even read aloud directly from the police report in front of the courtroom, demonstrating there was more than enough detail to file a charge immediately. Schmidt's office, the judge suggested, was choosing delay as a system, not facing it as a constraint. Here is the moment worth pausing on, the one that will likely end up clipped and shared on its own. The judge said plainly, if we're going to start having people arrested and brought before the court, then forthwith a complaint will be filed, and we will start having bond hearings every single time a person is arrested.
Cause. So if we're going to start having people arrested and they're going to be brought before the court, then forthwith a complaint will be filed and we will start having bond hearings every single time a person is arrested. This is outrageous. It is completely outrageous.
I would approve of that process. That's why Captain Taggart asked the court to...
Oh, good. Then we're going to start doing that now. And so we will have a complaint filed forthwith at the bail hearing, correct?
We will not.
Schmidt's response was immediate. We will not. The judge didn't blink.
Then we will not arrest people. Then they will be not arrested and we will not see them because bail should not be placed on a person unless a person is arrested
then
without...
Then we will not arrest people. That single exchange captures the entire conflict in 2 sentences. a judge willing to halt business as usual to protect due process, the constitutional guarantee that no one loses their liberty without fair legal process against a prosecutor unwilling to change a system that was, by his own admission, leaving people in legal limbo. So what happens to people stuck in that limbo? They live under bond conditions they cannot get clarified, risking violations for rules attached to charges they don't even know exist. Imagine being told you must follow strict conditions at work, but no one will tell you what policy you're actually being held to. That is what bail without a complaint does to a defendant's daily life. The judge ultimately ruled from the bench 0 bail, 0 bond unless a criminal complaint is filed within 48 hours of arrest going forward.
I agree.
So 0 bail, 0 bond, unless we have a criminal complaint filed forthwith within 48 hours.
I agree.
Done. Then that's what we're going to do. So, Mr. Campo, I'm not sure if you are supposed to have a complaint filed today. I'm hearing no.
Brandon Campo was discharged immediately. His cash was ordered returned. The bond, in the judge's own words, was
I'm hearing
gone.
no.
Okay.
So you are forthwith discharged from all bail bond conditions. Forthwith. Now.
Really?
Immediately. Cash will be returned to you. And bond gonzo.
Amazing.
Okay? Thank you.
Thank
For
you.
Campo, after 33 days, that was the justice he received. But here's the uncomfortable question this case leaves behind, and there's no single right answer. Should a prosecutor's internal staffing or workload policy ever be allowed to override a defendant's constitutional timeline, even when no one intended harm? Or is some delay simply the unavoidable cost of building a case correctly? You decide, because the comment section is where this debate belongs. The partial frustration here is real. Campo walked free, but the ruling only applies going forward. Schmidt's office faced no formal sanction. No charge was ever filed in his case at all. The system protected itself even as it corrected itself, and that contradiction is exactly why this case matters. The lesson is simple, and it's one every citizen should carry with them. The presumption of innocence is not just a phrase for the courtroom. It is supposed to mean something the moment handcuffs go on. When the people in charge of enforcing the rules quietly exempt themselves from those same rules, accountability only exists if someone in the room is willing to call it out. In this case, one judge did. If you want to see more real courtroom confrontations where judges hold power accountable, comment below with a case or courtroom interaction you want covered next. Subscribe and share this video because an informed public is the only real check on a system that depends on people not paying attention.